Hello, I'm William Flack, and this is the first of the commentaries on law reports which I hope to be producing. This one is on the case of University Hospitals of Leicester NHS Trust v TC and others, which is a 2020 Court of Protection case about depression. I think this is relevant to many lawyers, including housing lawyers like me, and not just to those specialising in court of protection work. There's a link to the judgment and other information about the case below. If you like this, then please hit the like button and subscribe, and do leave comments, they're all welcome. And so let's get on with the case. This is the case of University Hospitals of Leicester NHS Trust v TC and others, 2020. In this case, the Court of Protection considered the impact of depression on TC's capacity to make a decision as to whether to have an operation and whether she had capacity to conduct litigation. She had previously consented to having an operation, but was later considered to lack capacity to do so as a result of becoming depressed. After considering a psychiatrist's report, the judge applied the test for determining mental capacity as set out in sections 2 and 3 of the Mental Capacity Act 2005. He held that TC had demonstrated that she was able to understand and retain information in regard to her diagnosis and the treatment interventions available. She was also able to communicate her decision. However, he held that as a result of her depressive illness, she was experiencing symptoms of hopelessness and did not consider that she had a future. He stated that, as was typical with severe depression, TC was experiencing catastrophic thinking, and that as a result she was unable to weigh up the information she had been given in order to make a capacitous decision. He therefore concluded that TC lacked capacity to make decisions about her medical treatment. The judge went on to consider TC's capacity to instruct a solicitor and conduct these proceedings. He found that due to her limited motivation and sense of hopelessness, she would be unable to identify an appropriate representative and weigh up the necessary information to provide instructions. Therefore, it was his view that as a consequence of her mental disorder, TC was unable to weigh up the necessary information to conduct these proceedings and thus lacked capacity to do so. I found out about this article from the 39 Essex Chambers website, where there is a very useful report on the case. This points out how this case demonstrates the importance of promptly obtaining expert evidence with the permission of the court in cases such as this, even where the application is urgent. The expert evidence on capacity in particular was able to explain to the court's satisfaction how TC had gone from being able to capacitously decide upon her medical treatment to being in a position where she lacked the capacity to do so. That is to say, as a result of catastrophic thinking associated with her severe depression, she was unable to weigh up the information relevant to the decision in question. So now I'm going to have a look at the wider implications of the case. I think it's an important decision beyond the issue of consenting to medical treatment. It has a wider application for all lawyers and advisors dealing with persons suffering from depression. In the area of housing law, I've found that many clients who are facing eviction due to rent arrears were suffering from depression, which may have caused or at least contributed to their difficulties in paying the rent, maintaining benefits claims needed to pay the rent, and engaging with landlords or getting help with resolving their problems. The genuine difficulties faced by tenants have often been overlooked, and their rent problems have been attributed to laziness or some other deliberate decision not to comply with their obligation to pay their rent, such that it's considered to be appropriate for them to lose their homes. If medical evidence can be obtained, as in TC's case, to show that the client was suffering from a level of depression such that they lack capacity, they are likely to have a defence to a possession claim and grounds for applying to set aside or suspend a possession order, and the tenant's catastrophic thinking and sense of hopelessness may prevent them from weighing up the information needed to make decisions, such as whether to respond to correspondence or challenge negative benefits decisions. Like TC, these feelings may mean that they lack motivation to take action themselves and to obtain assistance from others, such as housing advisors or solicitors. The defence to a possession claim arises from the Equality Act 2010, which provides that adverse treatment of a person due to something arising from a disability, which the landlord was aware of, amounts to unlawful discrimination. Where a medical condition is sufficient to deprive someone of capacity to make a decision, then it will usually also amount to a disability. If it can be shown that a landlord is discriminating in this way, the tenant is likely to have a full defence to the claim for possession. Enforcement of a possession order which was made before the landlord was aware of the tenant's medical condition or before the tenant began to suffer from depression will amount to unlawful discrimination even if the original application for a possession order didn't. Where it can be established that the tenant lacked capacity and the landlord was aware of this when an earlier possession order was made, then it may be possible to have that order set aside on the basis that the order was made in breach of CPR 21, which covers protection of protected parties. It means that any orders made against a protected party before a litigation friend has been appointed will be void and should be set aside. Where a landlord continues to take action against a tenant for reasons arising out of a disability such as depression, then the tenant may also be entitled to a counterclaim for substantial damages for the distress caused by the discrimination. See the case of Poplar Harker v. White, 2015, unreported, where a tenant was awarded £4,500 damages where a landlord had pursued possession action despite being aware of the tenant's disability. Okay, so to end this video, I'd like to have another look at the tests for determining whether someone lacks mental capacity. To apply the test set out in the Mental Capacity Act 2005 in a case like this, the following steps need to be taken. Step 1. Carry out the diagnostic test and identify an impairment of the mind or brain which might give rise to a lack of capacity. In this case, the impairment which was identified was TC's depression, which gave rise to catastrophic thinking and feelings of hopelessness. Step 2. Carry out the functional test and determine whether the impairment is likely to prevent the person from making a decision for themselves. In this case, the catastrophic thinking caused by TC's depression prevented her from being able to weigh up the information which she had been given so as to make a decision. Section 3 of the Act provides that a person is unable to make a decision for themselves if they are unable to do any of the following. A. Understand the information relevant to the decision. B. Retain that information. C. Use or weigh that information as part of the process of making the decision. And D. Communicate this decision, whether by talking, using sign language or any other means. In this case, the judge applied the functional test and determined that TC was capable of understanding and retaining information and of communicating it. She therefore passed the test on grounds A, B and D, but failed under ground C as the judge considered that she was unable to use or weigh the information as part of the decision-making process. In practice, the test may best be applied backwards, that is to say, you need to identify whether the person is unable to understand or retain information, to weigh that information, or to communicate it. If you find that they're not, then you may want to find out whether there's some impairment that prevents them from doing so. Further information on depression and its impact on capacity can be found in the articles Understanding Depression and More Than Sad, Depression Affects Your Ability to Think, both of which are produced by the Harvard Medical School.